Stay tuned for the next edition of Zoom Landlord Tenant Talk Radio. The opening topic will be California stopping landlords from selling. Hello. Yes, another edition of Zoom Landlord Tenant Talk Radio coming at you precisely at 3 p.m. every Saturday. If you were listening live, the name of the song was Help by the Beatles. It was released in 1965, and it was actually written by John Lennon. Now, John was actually struggling badly in 1965 as the Beatles were globally famous, touring constantly, and he was under intense pressure. John felt trapped by his fame and an unhappy marriage and was dissatisfied with his own identity. He was at the time using a lot of alcohol and drugs, and his mental health was shaking. Years later, John described this period as, I was fat and depressed, and I was crying out for help. So really, this catchy song, which we all knew, was actually a cry for help by John Lennon. And the reason why I played that song is because California landlords need help. And we'll get into that with the opening topic. Let's talk about the show format. As we know, I do an opening topic. And then after that, those people that are in the Zoom meeting room, I will open it up for questions and answers. If you do want to talk to me, so simple. All you have to do is raise your hand electronically. You'll see that at the bottom of your toolbar. If you ever do want to watch this from the Zoom meeting room, you can get the credentials by going to my website, which is evict123.com. If you're watching this on YouTube, thank you very much. If you find the issues dealing with landlord, tenant law, and property management helpful for you, then I would appreciate it if you could hit that like button and subscribe to my channel, because it really does help me. So let's talk about the opening topic. And what is that? California is stopping landlords from selling their homes. It sounds incredulous, but it's certainly true. They are stopping landlords from selling their homes. Now, this not only impacts landlords, but it also impacts their real estate brokers, because if you can't sell the home, then that means that their livelihood is cut off as well. Now, when I refer to homes, I am referring to tenant-occupied single-family homes, townhouses, or condominiums. That's what I'm referring to. Obviously, if you're going to sell your property and it's tenant-occupied, you're going to need to ask that tenant to vacate the unit. This way, you'll be able to stage the unit, clean it up, and it also be much easier for showings and for holding open houses. So why can't you ask a tenant who's on a month-to-month tenancy in your single-family home, townhouse, or condominium, why can't you ask them to move? Well, the first issue is, are you subject to AB 1482, the Tenant Protection Act, also known as statewide rent control? If your property is subject to AB 1482, then you are required to have good cause to evict. You just can't serve a 30 or a 60-day notice because the tenant's on a month-to-month tenancy. By the way, of course, a tenant can clearly serve you with a 30-day notice if he's on a month-to-month tenancy, but it doesn't go both ways. If your property is subject to the Tenant Protection Act, statewide rent control, you need good cause to evict. Well, let me explain what good cause is not. Good cause is not that you're selling your house and I need you to move. Please leave. The tenant can tell you, since the property is subject to statewide rent control, and again, I'm only talking about single-family homes, townhouses, and condominiums. If your property is subject to statewide rent control, that's not a ground to ask them to evict. So the issue is, when is a single-family home, townhouse, or condominium subject to statewide rent control? Well, first of all, if the property is more than 15 years old, it received a certificate of occupancy more than 15 years ago, then it would be subject to statewide rent control. However, there are exemptions. single-family homes, townhouses, and condominiums are exempt, but only if title is held by a natural person, an LLC, a limited liability company, or a family, living family trust. Okay. And by the way, none of the members of a LLC can be a corporation or a limited partnership. They have to be natural people. In addition, even though I told you that uh, those types of properties are exempt, you have to conform with one more issue, and that is, and by the way, brokers, this is where you really do a disservice to your clients when you lease out property, is that you don't have the proper language in your lease. You need to have the proper language in your lease indicating that the property is exempt from statewide rent control. If you don't have that phrase in your rental agreement, and I know under the California Association of Realtor forms, there's a box to check, and I see time and time again that brokers do not check this box. And of course, if a landlord's doing the leasing himself, then he doesn't check that box, or he doesn't use a rental agreement which has that exemption language in it. So let's talk about when you're leasing out your property. If the property was leased prior to November of 2020, then you need to serve on your tenant, and you can do this right now. You need to serve a notice that this property is exempt from statewide rent control. I'm going to share my screen with you right now. This form is on my website in the free form section. And if you have a tenant in a single family home, a townhouse, or a condominium, to exempt it from statewide rent control, what you need to do is you need to fill out this form and serve it on your tenant. You can just mail it to them and keep a copy. And obviously you might want to do it with a proof of mailing. By using this form, okay, then your property is exempt from statewide rent control. And if you want to sell that condominium or you want to sell that house, all you need to do is to serve a notice to quit on your tenant. But what happens, and this really goes for you brokers out there, if you're leasing property after November of 2020, like you're doing it yesterday, then inside the lease, you have to have that exemption, has to be inside the lease for any property that was leased post November 2020. So in my rental agreement, which is online, if you go to paragraph 36, and by the way, all my forms are free. They're on my website, evict123.com. They're in the free form section. But if you go to my lease and you go to paragraph 36, you want to check that box right there. Check that box to show that it is not subject. Because if it is subject to statewide rent control, then you can't ask a tenant to move because you want to sell your property. You can't. So what does that mean? That means you could sell it with a tenant in possession, but then the question is asked, who the hell wants to buy it? If you're a buyer and you're going to sit there and now have to deal with a tenant in possession when you wanted to move it yourself, you know what? You're going to find another place. So you've basically, and the state of California, as the title suggests, is stopping the sale of tenant-occupied property for condominiums, townhouses, or single-family residence, because the fact that you want to sell is not a reason to evict. And if it's subject to statewide rent control, you need a reason to evict. Simple as that. So brokers out there, please, on the car forms, or if you're using my rental agreement, please check that box if it's a townhouse, a single-family home, or a condominium. You need that box checked, because what you're doing is you're hurting the future real estate broker down the line who wants to sell the property. And how are you going to stage this place? How are you going to make showings for this place? Now, of course, the buyer could buy it. And if he's intending to move in, well, then that's a great reason. And he can certainly go through the procedures to evict this tenant who's under statewide rent control. by merely serving the proper notices on the tenant and paying the relocation fee, which generally is 1 month's rent. But which buyer is really going to want to do that? For what reason? They're going to get involved in an eviction case if the tenant doesn't vacate? It's a simple issue that if I need to do something after I purchase this property, then I don't want to purchase this property. So what's the solution? Well, the solution to this is to raise rents. If you raise the rent, and again, on single family homes, townhouses, and condominiums, you are allowed to raise the rent to market value. That might have the persuasion to have that tenant vacate the unit. Now, you can't have the rent from $10,000 a day, because then it looks like you're indirectly trying to get the tenant to vacate the premises by just merely raising the rent. So you still have to be in the realm of reasonable market value. So I'm going to share my screen with you again. And in this example, we're going to see a website that I always recommend and that I have no affiliation with, but boy, they should put me on their payroll. And this is called Rent-O-Meter. The website is called rentometer.com. And this is free, at least for the first 5 times. And what you do is you put in the tenant's address, and right there, you put in how many bedrooms, how many bathrooms, and what type of a building. Like, is this a condominium or is this a single family home? And by doing that, what's going to happen is within seconds, you're going to get a rent comparison. So I have one here, which is a property. I have whited out the address of this, but it is located in Los Angeles. And as you can see here, what it says here, it says that results based on 27 2-bedroom, single-bath homes within a 12-month period that rented within the last 1.5 months. And as you can see from this chart here, that the lowest was 3118, the highest was 4,077, and the median was around 3,550. If we come down, and again, this is all what this rent-o-meter does for you in seconds, we can actually see all the locations which rented around your property. And then they actually give you the addresses of the other places and exactly what they rented for. So this is an invaluable tool if you're trying indirectly to get this tenant to move. Well, you can just merely raise the rent to at least maybe a little higher than market value, and that might be incentive, and that might be a solution to have that tenant vacate the unit when you can't ask them directly to vacate. By the way, this website, rentometer.com, is also excellent for landlords who are putting their rentals on the market and they want to see exactly what they can rent their units for based on the location of their unit and what kind of a unit it is and how many bedrooms, etc. So this is one solution that you can use. The next solution would be to do major renovation on that unit. So what is major renovation? You have the right to ask a tenant to move if you are doing major renovation. You have to pay relocation money, which is 1 month's rent. And major renovation is defined as work that would render the premises uninhabitable for at least 30 days. And that type of work requires a building permit. So if you're going to remodel the kitchen and the bathroom in this house or both, then you have the right to ask this tenant to move, and it might actually improve the sale value of your property by doing so. So that's one solution if you can't just ask the tenant directly to move, because you are subject to statewide rent control. Now, if you are planning that, you're going to need to get a contractor who will give you first the scope of the work, showing what work is going to be done and why it's going to render the premises uninhabitable for at least 30 days, and that the work being planned would require obtaining a building permit, like an electrical permit or a plumbing permit. You also have to obtain the permits. So once you have that scope of the work, once you have the permits, then You can call a firm such as ours, and we will serve on that tenant in that single family home that unfortunately is subject to statewide rent control because you didn't check the right box. And then we can ask that tenant to move. Now, you do have to do the work, but once that work is done, you have a vacant unit, you have an updated kitchen or a bathroom, and then at that basis, you'll be able to easily list that building for sale. Is there another solution other than major renovation? And that's pretty simple. It's called a voluntary vacate agreement, or a lot of people call it cash for keys. You can walk up to that tenant who you have no basis of asking that tenant to move because you're just selling, and you can say, you know what? The new owner, I'm planning on selling this. The new owner is going to ask you to move, which they will, and you're only going to be entitled to 1 month's rent. But if you're willing to move on an agreement with me, instead of giving you 1 month's rent, I'll give you 5 months' rent. Maybe I'll give you $10,000. Quite frankly, it's going to be worth it to you because you can't sell your property when it's tenant occupied. Nobody's going to want to buy it. It's going to look like garbage. You're not going to be able to stage it. And the choice between selling a property occupied and without, the value is significant. So you might want to pay this tenant. So that's one voluntary thing you can do by just entering into an agreement with him if he's willing to do it. If he's not, then all you can do at that point is to do the major renovation. Now, what happens if your property is subject to a local rent control? Well, if your property is subject to a local rent control, and we're going to use the example of the Gestapo city called Los Angeles City, and they are a Gestapo city, then it doesn't matter about statewide rent control. You're now subject to the city of Los Angeles. Now, just recently, the city of Los Angeles has included all residential units are included into the city's good cause to evict. So that would include all condominiums, all single family homes, all townhouses. Doesn't matter that they're brand new. You are now subject to the Los Angeles city. You're either under rent stabilization ordinance or you're under the just cause ordinance. If you're under, for all of these units, every single unit, if it's a residential rental, every single unit, including an $85,000 a month house in Brentwood, you have to register that unit. For those properties that are under just cause ordinance, you have to pay a yearly fee. You have to pay a yearly fee for RSO properties too, but you do have to pay a yearly fee of $31.05 for those properties under the just cause ordinance, which is JCO. And the only reason why the city instituted this, one reason and one reason only, it was a terrible money grab. Now, if your property is located in the city of Los Angeles, it's a single family home. You just want to sell your own home. You want to get out of Dodge. You want to sell the home and move to a state that's civilized, because certainly California is not one of those states. And there's a tenant in there, and you're subject to this local rent control, which says you need good cause to evict. Well, just like statewide rent control, selling the property is not good cause to evict. Selling the property is not good cause to evict. So what do? Can you do a substantial renovation? I'm willing to do it. I'll fix up the kitchen. I'll get my contractor. Well, in the city of Los Angeles, that is not a cause to evict. So you can't evict in the city of Los Angeles. Remember, I called it Gestapo. Remember that? You can't evict in the city of Los Angeles because you want to sell your property. You can't evict in the city of Los Angeles because you want to do a substantial renovation. So what else can you do? Well, the only thing you can do is to do a voluntary vacate agreement where you offer this person money to move, and there is no set amount. Everybody says, well, how much is the relocation? It could be $1, it could be a ticket to Disneyland, or it could be $300,000. It's whatever those people agree to. But that basically, unless you can find another reason, like the tenant is doing something wrong, like extra people, or they brought in an animal, or they're not paying the rent, you can't just evict the tenant because you want to sell the property. And you can't even evict that tenant now because you're going to do major renovations. Now, of course, if I do have a house and the tenant is refusing to move, even with a voluntary vacate agreement, the only thing you can do in that situation is to tell the buyer that, hey, you're going to be able to kick this tenant out once you become the owner. I can't do it because I'm not moving in, but you can do it. And you might even want to tell the buyer that you'll take care of the cost of doing that as part of the escrow once escrow closes. So I do want to talk about another small topic, and that is even in the city of Los Angeles, you can't even move into your own unit in certain circumstances. I told you can't sell, but you're telling me in the city of Los Angeles, I can't even move into my own unit? And the answer is yes. I had a situation with a client, this was a couple of 3 years ago, where he had a daughter who was just starting to attend the University of Southern California, USC. And he thought instead of her living in a dorm, that he would do an investment. He would buy a duplex in the city of Los Angeles near USC. He would have his daughter live there for 4 years, maybe rent out the other side of the duplex. And then after 4 years, if she wanted to stay, great. But if she wanted to move, he could sell it. And literally her housing would probably be taken care of for free because with the increased value of this duplex. So he bought this duplex and it was tenant occupied. Now, even in our Gestapo city of Los Angeles, you are allowed to evict the tenant if you want to move in yourself or a close family member like your daughter. But he didn't do his due diligence, and there is an exception to that. The exception is if the tenant in possession has lived in that unit for 10 years or longer and is over the age of 62, then that tenant is exempt from being evicted to put in yourself or a close family member. Well, as it would turn out, each of the tenants in this duplex were over 62 and had each lived there longer than 10 years. So he bought this duplex for the sole purpose of putting his own daughter in, and he was frustrated and he couldn't do anything with it he then sold that duplex to someone else, obviously taking a loss on this. So for you real estate brokers out there, please, before you tell somebody that you will easily be able to get somebody evicted, or maybe you can rent out that illegal unit in the backyard and defray your mortgage payment, make sure that you do check with a professional and do your due diligence before you sell this property to them. And that, my friends, concludes California is stopping landlords from selling their own homes. We're now going to open it up to those people who are in the Zoom meeting room for questions and answers. And we know the rules that this telecast is for informational purposes only. It is not a substitute for legal advice. If you do want to talk to me, electronically raise your hand. I'll take you in the order that you did raise your hand. You'll see that raised hand in your toolbar if you're in the Zoom meeting room. If you don't see it there, you might see it in a folder called Reactions. Also, if you are talking to me, please leave your camera on because it's much more enjoyable for myself and for the audience if we can see when you're talking what you look like. Those people who are watching on YouTube, if you do like what you see again, then please hit that like button and subscribe to my channel. If you do have a question, you can leave it in the comments, and I do get to most of those within the week. So feel free to leave your questions in the comments or your just general information that you want to give me. And with that, we're going to open it up with an old regular, though I don't know how old he is, but his name is Jim Polina. Say hello.
Hey, Dennis, can you hear me okay?
Perfectly.
Great. Hey, you know, that Laker game, third quarter, Utah, that was exceptional passing. That was a real joy to watch.
Yes, and I think we're playing Utah next in the next game.
How about that? Okay. Well, okay. So on your topic, the The inability to evict with a elderly tenant after 10 years, isn't there more to it than that? Like, for example, family with kids?
No, it's only a person who's, this is for RSO properties only, I might add. It's only for, you're exempt uh, from being evicted because the owner wants to put in a close family member or himself if the tenant has been there for over 10 years and is over the age of 62.
So if they have kids or if they're handicapped, that doesn't come into play?
That doesn't come into play.
Okay, second question. You didn't mention, I was kind of surprised that couldn't you just allow the lease to run out and not renew?
Well, under statewide rent control, if the tenant has been there less than 1 year, you don't need a good cause to evict. But if you are on a 1 year lease, for example, then you're stuck because by the time that lease is over, then you're going to need cause to evict. But usually what happens is the tenant's been there a year or two or three. So you're past that 1 year exemption period. And then you want the tenant to move and you don't have the proper language in your rental agreement. And on that basis, you can't ask the tenant to move because you are selling the property.
So when the lease expires, I have to offer it again. Is that correct?
Yes, if it's a 1 year lease. If it's a 6 month lease, and that's why I only recommend giving 1 month, month-to-month rental agreements. But if it's a 6 month lease, then after that, now we're talking statewide rent control,
Right.
then you can just say, I'm not renewing and please leave. But again, when you want to sell the property, usually you've made that decision. If you put a tenant in, you don't put a tenant in and then make that decision quickly. Usually some time is going to go by.
So again, on a month to month, I just can't, on statewide rent control, I can't just say, here's your 60-day notice, you need to go without a reason.
If the tenant has been there less than 1 year, the answer is yes. You can serve a 30-day notice to vacate without a reason. But if the tenant's been there longer than 1 year, you need cause to evict. And cause is not on the basis that I'm selling the property. We're going to move on. Thank you very much, Jim. Good questions. Moving on to Margaret O'Brien. How are you today?
Fine, thank you. I have a question regarding the 10% for extra occupants. I read that the city council has rescinded it. Does that mean I have three tenants that got additional occupants where I added 10% in rent-controlled units? So do I have to stop it? Or
First of all, I'm not aware that the city council amended their statute to prevent adding an additional 10% per occupant. I will look that up for you. But if at the time when you did the 10% and that was in accordance with the statute at the time, then you wouldn't have to rescind it. However, I have not heard that. So, but I'll make a note, and for the next show, I'll talk to you about that.
yeah, and then I have one more question, and that is rent-controlled house, two houses in a lot in San Pedro, and the uh, original tenant had her sister move in, and that was okay. And now the original tenant is going to move out, and the sister wants to get married and stay in the house. Do I need to write a new rental agreement? I mean, it's a married couple now.
Okay, well, first of all, the sister and the other person moved in together and they're both on the rental
No,
agreement?
no. The original tenant moved in with a boyfriend. They split up, and the boyfriend moved in, and then her sister came, and I checked her out, and she
So
was
where's
fine.
the boyfriend?
Oh, he's gone. The
Okay, so
boyfriend,
now the last original tenant has now moved out.
yeah, she's
Okay,
planning.
so you can do a rental agreement with the new tenant, but the good news is you're allowed to charge market rent. You're not limited.
Really?
Because under the Costa-Hawkins Rental Housing Act, it states that if you rent to A and then after the tenancy was initiated, B moved in, and then you've been taking rent from A, you've been taking rent from B, but then A moves out, you have the right to raise the rent to be to market level.
Thank you.
So
That's
that's
finally good news. There are very
something.
few good
But again,
news.
that's only under the Costa-Hawkins Rental Housing Act, and that was the last good piece of litigation or good statute that was initiated, and that was back in 1995. Anyway, thank you very much. Moving on to Sonia. How are you?
Dennis, hi. Hi,
Hello.
Dennis. Can you hear me? Hi. Great. Thank you. My question has to do with that requirement coming in January that we have to supply the stove, but also refrigerator to a tenant. So my question is now, does it matter what size? Because if we have a triplex and they're small individual units, can we get like the smaller refrigerators?
The code says that it has to be a standard size refrigerator, so they can be very small, but not the ones that like go under a counter, that type of a refrigerator.
No. Oh, okay. Okay. And then the next question is, so what if we have existing tenants and they have their own refrigerator and something goes wrong with that?
Okay, this bill only impacts new tenancies commenced as of January 1st, 2026, or where you renew the lease. So for those existing tenants, don't give them a new lease to sign.
Okay, so if we roll it over to month, are we still okay then?
You're fine.
Dennis?
Yes, I say you're fine.
Oh, perfect. Thank you so much. Appreciate it.
Okay, moving on to Farouk. How are you?
Mute. Hi, Dennis.
Hello.
Good to see you again. So I'm a little bit confused. I'm going to, my condo is in Tarzana, which is the city of Los Angeles, built in 1973, and the tenant has been there since 2008. I want to bring it up to market because I think it's a condo. I want to bring it up to market. I am using your form, says this property is not subject to rent limits imposed by section 1947.12, which I understand that I'm not, of the Civil Code, and is not subject to the just cause requirements of section 1946 of the Civil. But I think I still have to have just cause to evict her.
You do
Correct?
have to have good cause. That code
But
section that code section refers to statewide rent control, but you're under now the just cause ordinance for the city of Los Angeles. So you do need good cause to evict under the
Correct.
city law. But again, you don't need you can raise the rent to market value because it is a condominium, and I don't care where it's located. I don't care what's in your rental agreement, and I don't care when your tenants moved in. So raise it to market value.
Correct. But should I leave this statement the way that you have it on your form? It doesn't matter,
Yes,
even though
it doesn't matter. You can leave that because it's true. It's not subject to statewide rent control, but it is subject to the local rent control, which is the just cause ordinance for the city of Los
but I
Angeles.
can leave it anyway. And then I am exempt from statewide rent control AB 1482. Yes.
Yes,
Yes.
but
Thank
again, it's irrelevant because you're subject to local rent control.
Okay, one more question. Every time I do a rent increase, do I still have to go and put on a public space the renter protection notice and
Okay, the renter protection notice has nothing to do with a rent increase. Under the rules for the city of Los Angeles, you have to have the renter protection notice, and in your case, also that this property is subject to RSO, and also that you're entitled to free legal help. Those three types of notices must be posted in a conspicuous spot for your property because your property is subject to RSO.
So if I've done it once, last rent increase, I don't need to go and post this again.
It just has to be posted in a conspicuous spot. If somebody ripped it down, put it back up.
Well, I wouldn't be
Anyway,
able to see it. It's in front of her house. I'll go post it again for her. Okay, thank you, Dennis. Thank you.
thank you. Okay, we're moving on rapid fire to Mimi H. How are you?
Hi, I'm good. How are you doing?
I am good, thank you.
I have a question for you. As a tenant, there's actually a few tenants in my building. We won a judgment, which was for an unlawful rent increase. it was in the middle of October. It's already been 30 days. They did not appeal, and they still have not paid. I was just wondering what would be the next steps to take.
Well, you'd want to go through a collection procedures. And by the way, we do welcome tenants calling because it's good to hear the other perspective as well. So if any tenants listening, feel free to come call in with your questions as well. And of course, subscribe to the channel. First of all, the person who you sued, was it an entity or was it an individual?
It was an entity.
Okay, so like an LLC?
Yes.
Okay, so what you first want to do is if you've made a demand for payment, okay, there's a few things that you can do in terms of collection. Number one, you could file an abstract of judgment against the property. That's a form that you'll get that you can get from the courthouse. And then once that form is entered by or issued by the court, then you record that judgment at the county recording office. If this property is ever sold or refinanced, you'd have to get paid. And in addition, you're going to get paid not only the amount of the judgment, but now you're entitled to interest at the rate of 5% per annum. So that's the first thing that you can do.
Okay.
Again, you need to make a demand on that owner to do so. The next thing you can do is you could hold a judgment creditor hearing. That's a form, again, that you can get from the court where you serve it on the managing member of the party and where you're going to demand that he show up someplace and you're going to be able to ask him questions as to where are your bank accounts, et cetera, and what other assets do you have. Obviously, if anybody's paid by a check, then you know where the LLC banks, because you just have to look at your check and see where it was deposited. And on that basis, you could also get something called a writ of execution for money. That's a form you can get from the courthouse. And then with that writ of execution for money, you bring that to a sheriff's office with sheriff instructions, and then they will grab money out of that bank account.
Oh, okay.
And there's a bunch more things you could do, but that's some food for thought. How much is the judgment for, Mimi?
Well, for me, it's over $5,000, and then for other tenants, it just kind of varied on how much they had paid for the increase.
You might try to tell the landlord that, listen, I'm just going to take it off the rent, so I'm not going to pay rent for 2-3 months or whatever it is, and see what his position is.
Okay.
Good luck.
And then, sorry, one more quick question just related to all of this. Would there be a way to just kind of, we've already done like the demand for payment, like via mail and email. Do we have to do the abstract of judgment, or can we just kind of go to the courthouse and file that creditor form?
Well, you
and
could
then take it
file
to
a
the-
writ of execution and then deliver that to a sheriff. I mean, that's the way we collect on our judgments.
Oh,
So,
okay.
okay,
Okay.
thank you, Mimi. Good question, and nice that a tenant called. Suzanne, I'm going to ask you to unmute yourself.
Dennis, can you hear me?
Perfectly.
Hello, I'm calling about one house in Long Beach. It's actually two houses on a lot, and I wanted to find out if the requirements for Section 8 still include that it has to be a 1-year lease.
Section 8 does require that you have a 1-year lease. So if you're trying to avoid Section 8, I would just, from this point forward, and I think it makes sense for other reasons that I've already talked about on this show, just do month to month. And you're happy to rent to a Section 8. If they reject you, well, then that's not your problem because I'm happy to. But my procedures on how I rent out properties is month to month.
Okay, one other question regarding the refrigerator starting in January, and this has happened quite a bit in some of our other rental units. So we have the nice new shiny fridge in there starting January 1st, and then people come along and then they're like, "Oh, wow, I have my own fridge. I really want my own fridge." And I mean, I know you could make some, you know, obsessions, or what would you do in that case?
Well, I mean, if the tenant wants to bring in their own refrigerator and you don't mind it, then that's fine. That's good because then if it's his refrigerator and if it breaks, then he's responsible for repairing it. So I don't have a problem with that. But if you have, quite frankly, no place to store this refrigerator, then you have to tell the tenant, look, if you want to move in, then you ditch your own refrigerator because this is the refrigerator that comes with the unit.
So you would definitely, with this two-bedroom house I have, you would definitely have a fridge there January 1st. You wouldn't leave it without the fridge and then get the fridge after you
Well, you can,
sign the
before you
tenant.
lease the premises, you have to either get the tenant to sign an exemption saying, I'm using my own rental agreement and have them put it in writing, or you're going to have to supply it. So you might want to wait and see that the applicant that you finally decide on, whether he wants his own refrigerator or he wants you to supply it.
Perfect. Okay, thank you so much, Dennis. Thanks for everything you do.
My pleasure. Jeff W., come on down.
Okay, hi. We met at the AOA meeting the other day at the end. So I have about 4 questions, if I may. Can I give you a little introduction as to my situation and then go to the
Sure.
4 questions? Okay. So it's an older house in Van Nuys, built in 1950. My sister purchased it from the original owners in 2011 or so. She passed away. I inherited the property. It's only got it doesn't have it's owned by me individually in my revocable trust. I've had 2 tenants. The most recent one was started in June 2019 before the requirement for the
Pandemic.
exemption. However, I naively opted for security, and we've had one year renewals ever since 2019. The original lease does not have the 1482 exemption. So,
We know the original lease didn't, but you're saying you do new leases each year?
yeah, it's basically my property manager just did a 1-page addendum saying that the lease, the lease is going on for another year at the new rent rate.
Okay, so then that means that that property is going to, well, you're in the city of Los Angeles, so it doesn't make any difference. It's irrelevant because the city of Los Angeles has the just cause ordinance.
Right, it's a just cause. And by the way, Zemus and the assessor put this as a non-RSO.
You're right. It is a non-RSO property, but it is under the just cause ordinance.
Right.
So if you wanted to sell that property, and that's only because you're in the city of Los Angeles, you can't ask that tenant to move. And I don't care what's in the rental agreement, what exemption language, it's irrelevant because that's not a ground to evict under the just cause ordinance. Which, by the way, have you registered that with the city of Los Angeles?
Yeah, I paid the money and registered it.
Good.
But what about I started with this about 4 weeks ago. I started with the California Apartment Association up in Sacramento, and then I joined AOA, and I'm still, trying to figure all this out. I've seen some things like there's a notice of change in terms of tenancy. You had it yourself, where you can, after the fact, put in the 1482 exemption.
Right, but again, that has no applicability for the city of Los Angeles.
Oh, it doesn't.
It's only outside the city of Los Angeles, which would otherwise be subject to statewide rent control. If there is a local jurisdiction where your property is located, then your property is subject to that local jurisdiction, and you can forget anything about statewide rent control.
I see. So I'm stuck with
But again, you can raise the rent.
I can raise the rent to market value. It's currently under market value. It's currently under market value by about $400 a month.
Well, then get yourself out of hand. Are you on a 1-year lease now?
The lease ends in June. It was an extension of 1 year, probably actually 11 months.
Okay, so that's not so great. So you got to wait till June, but in June you can raise it to market level.
That was one of my questions. Do I have to wait till June? So you're saying yes.
Yeah, you can't serve a rent increase notice during the term of a lease. You have to wait for the lease to be over. Then you're going to serve I presume it's going to be a 90-day notice plus 5 days for mailing. So if it's over June 1st, then on, let's say, June 5th, you would serve that 90-day plus 5. So that would be July, August, September. It would take effect in November, 1 year from today.
So I can't do it like in December, or rather
No,
in
you
January?
can't do it. Technically speaking, you can't do that. Now you can walk up to her in June, on June 1st of 2026, and with a new rental agreement saying, hey, I'm raising your rent for $400. If she says, if she signs it, you're fine. If she refuses to sign it, then you got to wait for the current lease to expire, and then you serve your notice.
Okay, let me repeat to make sure I understand it. The lease actually ends June 30th. So on June 1st, I can give her the new
No,
lease.
if it ends June 30th, my friend, then on
Yeah.
July 1st, after the lease expires,
I see. That's when I have to give her the new
new rent
tenancy.
increase notice, or you can you can do it right now. You can give her a rental agreement right now that's effective as of July 1st, and it's raised the rent $400. You can do it anytime. But if she's refusing to sign that, I mean, you would walk over there sometime towards the later part of June and say, hey, your lease is up. I need you to sign a new one, and the rent's going up $400. If she says no, then you'd have to do the rent increase notice. Anyway, not only did you join the California Apartment Association and the Apartment Owners Association, but you know what else you did? You
What?
joined, Jeff, you joined Zoom Landlord Tenant Talk Radio, and welcome aboard. We are going to move on to Albert. I'm going to ask you to unmute yourself.
Hi, Dennis. Thank you so much. In regards to rent increases, I understand that last week we talked about and it's 2.7 now, correct, for City of Los Angeles homes
No,
or
so
units?
far, the City of Los Angeles for rent stabilization units, they have passed a law, but it's not effective yet. It has to be written by the city attorney, then it has to be signed off by the city council, and then finally signed by our wonderful mayor, Karen Bass. Once that's signed, I presume it's going to go into effect immediately. If you have the right to raise rent now, and in the city of Los Angeles for RSO properties, it's a whopping 3% plus 1% for if you supply the electricity, and also 1% if you supply the natural gas. But once that gets passed, then all you're going to be able to get is 2.7% with no increases on utilities.
Yeah, but we raised rents, if you remember, because of pandemic in February. So should I give notices now for February
It's
1st of 2026?
It's not going to be effective. You'll have to roll it back. You have to wait. This law is going to be effective. The most you're going to get is 2.7%.
Okay, and should I just basically go and give it, like put it on the tenant store, or we have to mail it as well?
Not sure I understand that question. What was that?
The uh, the notice for the rent increase.
Yeah, I would
Notice to
wait till the city passes this law. It's momentarily, and see when it becomes effective. Because right now you can't do a rent increase until February 1st anyway. So anyway, thank you very much. Moving on to Brent E. How are you? Brent E., I'm going to ask you to unmute yourself. Okay, Brent.
Sorry, Dennis. I'm here.
Good.
Apologize. My camera doesn't seem to be working that well, but it's maybe on the. I guess they're never on the trivial side, but so we have a couple of multifamily structures, older structures, so they're definitely RSO, etc. But they're on a couple of assessor parcels, if you will, and we are a member of AAGLA, and one of the gals there, they were only trying to help, obviously, said you need for your postings, they need to be on each individual assessor parcel. And yet their juxtaposition, if I'm making sense, you look at them, you'd say, oh, it's almost the same building. Do we really need to have?
Okay, if they're on separate lots, the city of Los Angeles is requiring that certain notices be posted. Are there multiple units on these separate lots?
Yeah, yes.
Okay, so you've got to post it on each lot. That's just what the law says.
Okay. All right. Thank you.
Thank you. Brent, appreciate you. Moving on to Harold Rhodes. How are you?
I am okay. This is such a it's like a being in a classroom because we're constantly having to learn and relearn and new learn. It's never ending, man. It's just like insane. Thank God you're at that. Oh, it's like we're on the remember Star Trek, Captain Kirk. We're all in there, and then all this chaos is coming up. It's like this every week, new crap. So, anyways, to your topic about the exempt from statewide rent control. What? How is if I didn't give that out to somebody? You were saying you could get them to sign an agreement and then it makes it enforceable? Because I thought you can't do that once they've already rented the place and it's too late.
No, if you rented it out, let's say you rented it out in 2022 and it didn't have that exemption language, if you get them to sign a new rental agreement that has that exemption language, then you're fine. Then your property would not be subject to statewide rent control.
Okay, but back to the statewide rent control argument. The purpose of that was so that you could sell the property and they can't tell you what to do, but that doesn't even matter because Just Cause runs it. So what is the effect of the statewide being exempt from statewide rent control up here in the city of LA?
Well, again, what you're talking about is that statewide rent control is jurisdictionally provisioned for properties that don't have a local rent control statute. So that's what I'm referring to. Like, for example, if you're in the city of Burbank, where my law practice is, they don't have rent control, though they're trying to pass it. So that would be then subject to statewide rent control. You'd have to have the exemption language in your lease. Otherwise, you wouldn't be able to tell this tenant in a single family home, I want you out because I'm selling the property. But if your property is located in the city of Los Angeles, forget everything I said about statewide rent control. You're subject to the local rent control. And in this case, it would be under the Just Cause ordinance for the city of Los Angeles.
Got it, man. And bro. And go Lakers.
Thank you. We're actually doing pretty good. LC Fong, how are you? LC Fong.
Hi, how are you, Dennis?
I am fine.
We met a couple times at the AOA convention. And okay, so my situation is I have a Section 8 tenant. I know you don't recommend it, but I was looking for stability. And the house got flooded over the weekend. And we went over, help out to clean it out. And unfortunately, the renter's insurance and our insurance does not cover flood. We didn't have flood insurance. We didn't expect it would be flooded due to the heavy rain. And so tenant doesn't have the means to pay for the temporary relocation. So we pay out of our pocket. We use your lease. So the temporary relocation would be the rental daily rate, but we pay a little bit more just to help out. The tenant is starting to play games. First, we rent an Airbnb, but then they say, oh, they found red droppings, and they left, they move out. So instead, I pay them the temporary relocation, and then in between, there's all these little stuff here and there. Bottom line, so now tenants said they want to terminate the lease. I was like, great, that's awesome, that's good. We won't exercise penalty. However, I do need a termination date. I need to know when, you need to give me a date because all the belonging needs to be removed. But tenants hasn't gave me the date. And instead just keep coming up little things to complain every day. Just like yesterday, because the house is under dry out service and then going to be renovated, like new floorings and stuff. So I have to go in there to check quite a few times a day.
Right. Let me stop you here. The tenant is not living there right now, correct? They can't.
Correct.
Okay,
Correct.
so what you need to do is you need to start the work with or without their permission.
Yes.
And serve an access notice that for the next 3 weeks, we're going to be changing floors in this. If they don't want to get their stuff out of the way, then it's your job to move it around within the unit. So, to move everything into the bedroom and then work in the living room and then move everything back. So you're doing it room to room. With regard to the fact that you use my lease, I would take a look at the paragraph in my lease that deals with renters insurance. that paragraph says that the tenant has to have renter's insurance that will cover not only the damage to their personal property, but will also cover the expense if they have to temporarily relocate, and that they cannot ask you for any compensation because they're supposed to have their own insurance policy. So if they didn't have it, then you're still not liable. However, it's not a bad idea to at least, obviously, you don't want to charge them rent for the time that they weren't able to use the property. So obviously the rent would be suspended. But other than that, you have no further obligations if you use my rental agreement. And that's why we actually put that paragraph in there. So we don't have to demand the tenant as to when you're going to move and this and that. If they want to move, great. Then whenever you're ready to tell me, tell me. But right now, I'm getting my place fixed, and your compensation is whatever the rental agreement says and not a penny more.
Correct. That's what we are doing. However, a tenant is not giving me a move out date.
So who needs a move out date? Just get the work done. The tenant doesn't necessarily have to move.
We are getting the work done as we speak. They said they want to end the lease. They want to terminate the
Okay,
lease.
but they say that and they're not giving you a date. Just ignore what they're saying. It doesn't matter. Your job, get the place fixed. You're already fixing it, great. When the premises are totally restored, if a tenant wants to come back in and pay full rent, then that's great. If the tenant doesn't, then you can evict them for non-payment of rent. And that's how I would handle it.
Okay, so starting December 1st, if they don't pay their portion, then we will serve the notice pay or
Well,
quit.
I wouldn't, on December 1st, assuming the house has been
ready.
remediated. Okay.
Yes,
All right.
correct.
All right, thank you very much. Moving on to Israeli broker. That's an interesting title. How are you?
Doing well, Dennis. Thank you for your time. So question for you, single family home, LA City. The tenants have been there for over 10 years and they're seniors today. No lease violations and they're on a month-to-month lease right now. The home is in complete disrepair, like termites are holding hands to keep the structure up. I need them out. What is the path of least resistance? They do not want to move out because their rent rate is super low, and that's their incentive to stay and live in those conditions.
Okay, well, first of all, you are allowed to raise the rent to market value. So the only reason why the rent is low is because the landlord hasn't raised the rent, because you certainly have the right to do so. If you need to do work on the premises, when you're saying that obviously you need to have the place termited, so then you're going to have to ask the tenants to vacate for a certain period of time so that you can get the premises free of those pests. Is there other work that needs to be done?
To cut you off, the home needs to be demolished, period. There's nothing that can save the home. It's good money after bad. So that home needs to be demolished. Everything is deteriorated and water soaked.
So you are planning on demolishing that house?
Yes, yeah.
Now, it's not going to be a remodel. You're going to demolish it. You're going to get yourself a brand new certificate of occupancy.
Correct. I don't know that I'll rush to demolish it because of the cost involved between permit, demolition cost, and maybe whatever.
Well, if you're not going to demolish it, you have no basis of asking the tenant to move because you need to permanently move because you need to do the work. So what I would do is I would serve a rent increase notice. I would also tell the tenant that I'm going to need you to be out for X amount of time while the work is being done, but we are increasing your rent. And maybe instead of doing all of this, maybe, Mr. Tenant, you'll accept my wonderful $25,000 offer to move.
What if I call building and safety on myself?
It would make no difference. You're still the city would make you do something called the tenant habitability plan, where you have to pay substantial relocation money to this tenant to temporarily relocate. And then the tenant gets to come back if he wants.
Even if I choose not to do anything to the property? Let's say
if you choose not to do anything into the property, you're going to get cited by building and safety. And if you still choose not to fix it, then they can hold you for misdemeanor charges.
That's interesting. Even if I don't have the means to rectify.
The city doesn't care that you don't have the means. If you don't have the means, then you sell your property and then let the next guy do it. Anyway, thank you very much. Good questions, I might add. Veronica, how are you?
Good, Dennis. Thank you. 1 second. Sorry. You guys see me?
I see you.
Orange County, single family residence, unincorporated. So I'm gonna read my question here. So my tenant signed a 2-year lease renewal shortly after I declined their request to remove the luxury wallpaper in the property. They began making repeated habitability allegations that were disproven by all the licensed mold remediation contractors that I hired for. And then reported me to code enforcement and health agencies, which also didn't find any issues with the property. Is that considered bad faith tenant conduct under California law?
Well, there is no bad faith tenant conduct laws. There's only bad faith landlord laws in this moronic state. Did you say you just recently signed a 2-year lease with them?
They were on the property for a year, and then we did a 2-year lease renewal.
So you did a lease renewal for these tenants that drive you crazy?
Yeah, that was my fault. And then shortly after, they started sending me probably 20 or 30 maintenance requests, which I dealt with every single one professionally. And then last night at 11:59 p.m., they sent me an email that they left because constructive eviction.
Oh, that's nice. I mean, you could say whatever you want. You could say you were
Yeah.
born on the planet Mars, but it doesn't really mean anything.
Okay.
The whole problem here, young lady, is that for some reason you signed a 2-year lease, which I don't recommend signing any leases. But if the claims that your tenant making are not legitimate, then guess what? You ignore them. Anyway, thank you very much. Even though we're past the hour, I'm going to take my last caller, which is Veta. How are you?
Hi, Dennis. Thank you. I have a triplex in the city of Los Angeles. It was built in 1905, but the city rehabbed it completely and offered it in a program for teachers, firefighters, and police officers. So it's been completely rehabbed since 2006. That's does it still makes it I want to know if I'm still under RSO.
You're
If it's
still
been
under
complete.
RSO because the law states when it first received its certificate of occupancy.
Okay. All right. Thank you, Dennis.
And thank you. And everybody, appreciate everybody coming out. We had some really good questions today. And in fact, we even had a tenant coming on. So you brokers out there, I sure hope that you remember the part about checking that box when you're dealing with a single family home outside of a local rent control area, because you guys, by not checking that box that it's exempt for townhouses, single family homes, or condominiums, you just get the owner of that property into a peck of trouble. Anyway, you guys have a great weekend and we'll see you next week. Thank you.